Secretary-General, what were the reasons to undertake this amendment process? Is this a normal course of periodic amendments, or was it in reaction to all the ISDS critiques?
Exactly. And I think it's fair to say it's a little bit of both. It's been 12 years since the last one, so it perhaps was time with periodic updating. In addition, at the center, we've been doing a lot of things that you might call best practices, and we thought perhaps it was time to memorialize some of these. And at the same time, obviously, we're very much a part of and aware of the big discussion about investor state and reform of investor state. And we thought that perhaps there was something we could contribute in this sense. When you talk about this reform discussion, if you follow it, there are obviously a lot of things that I would call purely substantive, and those are obviously not things that we would try to tackle in a procedural reform or a set of procedural rules. But if you put aside the substantive issues, there are a number of procedural issues that are discussed, and we felt there were a number of procedural issues where there would be consensus on some changes among states, and that we could do a lot and make some very big differences by looking at those and making proposals. So out of that notion came this 3-volume set. So.
What are some of the specific examples of pressures and concerns that triggered the process?
Yeah, well, there are a lot of them, and I don't think any specific one, but obviously there's been a huge discussion generally about transparency, and that resulted in the Mauritius rules about transparency and disclosure of documents, so that was one of the big influences. There has been a huge amount of discussion on third-party funding, and you're probably aware, for example, of the paper that ICA put out I guess last summer, about third-party funding and the committee that they had. There's also been a lot of discussion, in particular domestic legislation in Singapore and in Hong Kong with respect to third-party funding, and a number of countries addressing third-party funding in their domestic legislation. So there's been a lot of discussion about third-party funding, and certainly it was one of the things where we got a lot of comments. And I know you and I are going to talk about the specific provisions in a few moments, but that's one of the examples where we got comments all across the spectrum, everything from it's a great idea, there should be more third-party funding, to ICSID should ban third-party funding. So there was a huge variety of views that came up on third-party funding. We've received a lot of suggestions, I'd say probably in the past 5 years, about alternate dispute resolution, and in particular states saying they wanted more access to mediation and mediation tools. So that was one of the things we responded to. And probably the biggest one and most consistent comment we get is time and cost. Investment arbitration is taking too long, it's costing too much money. Is there a way you can address this through procedure? And you'll see in a number of the provisions we've tried to address time and cost, but at the same time try and first of all keep the balance between investors and states, or claimants and respondents, and also to try and have a realistic view. How long should a case take? An expectation that an investor state case would be done in 3 months is a ridiculous expectation. So, you know, we could have put in expedited arbitration rules saying 3 months, they would never be used. So we thought you have to try and have a reality check on this and improve what you can, but there needs to be a legitimate amount of time for the process to work itself through.
So which of the concerns do the proposed arbitration and conciliation rule amendments actually aim to address directly?
I mean, I think all of those and more. And it was certainly a dynamic project. We did not start out to do a 3-volume War and Peace kind of tome. And I have to admit that the irony is not lost on me that something which in part is intended to reduce paper, if you print, this is volume 3 only, that is not lost on me, which is why from now on it's all USB. But there were a number of initiatives, and as we started to work on it, it was an amazing process for us to work on, because it's very dynamic, and as you kind of fix one thing, then you get to another and then another issue. And I think as we started, one of the sort of overarching directives we took was that we wanted to simplify language, and in particular to put gender-neutral language, which I found out very late in the game, and I should have known well before that you can do gender-neutral in English. Gender-neutral in French and Spanish is a lot more difficult. And so we basically drafted in English and then got to translation, and all of a sudden it was, oh my God, there's brackets and E's and S's and accents. So a lot of this was a learning experience for us as well.
And what are the overarching objectives of the proposed rules?
Well, essentially, modernization. We thought that it would be very useful to offer, I think, what you can call a suite of dispute settlement tools. And so you will see that obviously the arbitration rules have been updated, the conciliation rules have been updated and are really much more sort of, they look like a flexible, 2018 type of set of rules. We really revamped the fact-finding rules, which had never been used before, but we thought this could be a very valuable tool. So we did a real rewrite of those, and in the additional facility, we've added a set of mediation rules. So the thought was to offer basically a suite of dispute settlement tools, and I hope that over time, they're not seen as you have to pick one or the other, but in fact, that parties will start thinking, well, maybe we do something in parallel, or maybe there's a particular area where a fact-finding would be useful, but the rest should go into arbitration. And the idea of being able to sort of flexibly use a number of the rules as opposed to just a binary, is this arbitration or conciliation? So that was one of the big things. Simplification was one of the things that we were trying to do throughout. We wanted to make this user-friendly in terms of language and organization, the reduction of cost, and as I say, go green, and I know I may eat my words, but go green was part of it. For those of you who have been at ICSID, you have seen the millions of banker boxes, and it was really time, even though we've been trying to go electronic, really time to push that. So essentially that is the default now in the rules. Everything will be electronic. And all of this, well, again, maintaining the balance with investors and states.
So let's now explore the heart of some of the arbitration rules proposals that govern the procedural aspects of ICSID proceedings. So I'll start with the hottest topic, third-party funding. What does the proposed rule provide for, and how does it define third-party funding?
Exactly. Well, what we've done is, just because it's easier to talk about these things with the text in front of you, third-party funding was one of the topics where we had the most diversity of opinions. And as I say, everything from allow more to completely ban third-party funding. There was a whole spectrum of commentary on that. And I think maybe as an aside, I think you'll probably see throughout, one of the things that we were very conscious of is we wanted to put forward a package of rules that we felt would be certainly progress and moving forward, but agreeable, obviously, to a core mass of states. So, there were lots of options, but we needed to always keep in mind, what is it that is going to work for a core mass of the member states who at the end of the day vote for this? So on the third-party funding, the question again was, how extreme do you go, or to what extent do you simply not address it? And where we came out on third-party funding essentially was a duty of disclosure. So what the third-party funding rule says is at the earliest possible moment, each party must advise whether they have third-party funding, and if so, who the funder is. And we've tied this very much to avoiding conflicts of interest. So for example, if you are a claimant, presumably if you have third-party funding before you even file your request for arbitration, you would disclose in the request that you have third-party funding and who the funder is. We did not require the actual disclosure of the document or of the terms of the funding or further details, because we felt that wasn't necessary to avoid conflict of interest. What you really need to know is the fact of funding and who the funder is. To complement that disclosure obligation, we have included in the declaration that an arbitrator will sign a number of other obligations, but including specifically that I have no conflict or no relationship with funder XYZ who would have been disclosed under this rule. So those two work together. When we did this third-party funding, one of the difficult things is just to define third-party funding. There's obviously no agreed definition of it, and we went through all the materials we could find, including some of the recent treaties that address third-party funding. So we came up with what I think is a fairly basic definition, but obviously provision of funds or other material support by a non-party to a party for the pursuit of a case. And you'll note it applies both to claimants and to respondents, and that third-party funding does not have to be sort of a for-profit or for remuneration basis. And when we thought about this, obviously it's part of the keeping the obligation balanced, but we've also had a fairly recent example where a state received third-party funding, and this is the Philip Morris third-party funding, where a number of organizations, I think Bloomberg Foundation was one of them, provided funding to ensure that the defense was able to move forward on that case. So I think while you probably more often and probably more accurately think of it as a claimant tool, it is certainly something that respondents may use. So we thought it was important to make sure that it applied both to claimants and respondents. It is a continuing obligation of disclosure throughout the litigation, and essentially each party has an obligation as soon as they have the third-party funding to notify the Secretariat and to disclose who the funder is. So that's the essence of the third-party funding obligation that we have. And certainly it's to be expected that there will be those who feel it should have, gone farther, or that people should have had to divulge the actual third-party agreement. But our feeling was, what is necessary to avoid conflict of interest? We really keyed on the conflict point, and really what you need to know is the fact of funding and the identity of the funder. And so that's what we did here. Some tribunals have actually looked at the terms of third-party funding and have gone farther into the detail of it. This is something a tribunal might be able to do, but it would depend on the fact circumstances. So we didn't think it was appropriate to put it in the rule, and that is something that parties would obviously address on a case-specific basis with their tribunal. So it's just not addressed in the new rule.
And there's a related provision on security for costs. Could you tell us how it will change the status quo?
Yeah, that's an interesting one as well. Security for costs was one, I think in particular, that a number of states were especially very supportive of when we got the commentary. And we thought it was time to put a distinct rule for security for costs. So essentially, we have said a party can apply for security for costs, and we've required the tribunal to address this relatively quickly and to issue a decision on an application for security for costs within 30 days. Probably the trickiest part here is, what should a tribunal consider? And again, obviously, a tribunal has to consider the ability of the party against whom the costs award is made to actually reimburse the costs. But we didn't want it to be a one-sided obligation. And, we sort of brainstormed about how many different facts might be relevant to whether security was appropriate or not, or how security ought to be affected. So we included all relevant circumstances, and also an obligation for parties to disclose a change in relevant circumstances. So if, for example, you received an order for security of costs under this rule, and the basis upon which you received it changed over the course of time, you have an obligation to go back to the tribunal and disclose that, and the tribunal has the ability to revisit that order if they think it's appropriate.
What are the proposed changes in the procedure for disqualification of arbitrators, which is another topic that attracted a lot of commentary?
Yeah, the ICSID system for disqualification of arbitrators is one that's received a fair amount of commentary. And I think this is probably a very good example of some of the I think constraints we had to work with. Essentially, there are certain things that are baked into or hardwired in the ICSID Convention, and this is not a process to change the ICSID Convention. This is a process to amend the rules. So, for example, the one that I hear about most frequently from parties is the rule that where there is a challenge to one member of a three-member panel, the other two members decide the disqualification. I think if there's any ICSID rule that we always hear about, that is one of them. That is in the convention, so this set of rules does not change that. So what we decided to do, first of all, was procedure. And the question was, how can you speed up the disqualification process? And we have heard a number of parties say that they feel disqualifications take too long, that sometimes they are used strategically or tactically in a case, and that it can be very disruptive, obviously, to going ahead with the merits. So we made a number of changes that I think all go to the issue of time to process a disqualification application. The first one was an obligation to bring your disqualification motion within 20 days of the time you knew or first should have known of the relevant facts that it is based on. And the ICSID rules used to have bring your application promptly. And of course, we would end up with debates about what is promptly. So it's much easier to debate what is 20 days, and that's the first part we put into the rule. Secondly, in terms of briefing, essentially, we said if you're bringing this motion for disqualification, the applicant has to simply file the application with all supporting materials and with their arguments. So you are right into the mission of the disqualification motion immediately. Within 7 days, the party responding has to respond with their argument and their materials. Then arbitrators are given a period of 5 days to make comments, if any. And one of the things we put into this rule was that arbitrators should make comments, if any, about facts that would be relevant to this. And the genesis of this is that a number of arbitrators who've been in this circumstance, and parties as well, have said, what are you expecting? Do arbitrators have to make observations? And, should they be arguing why they shouldn't be disqualified? And really, what it's meant to do is give you any missing facts that would allow an evaluation of whether there is or isn't a disqualifying conflict. So we decided to clarify that, that the arbitrator could make relevant factual determinations, and then the parties have a further 7 days to make final simultaneous submissions, and the tribunal must decide within 30 days. So that is, I think, a fairly eclipsed timetable. I think it adds up to about 50 days or just under 50 days, which I think is pretty good, while at the same time giving the opportunity for observations. I think it's a relatively expeditious pace, which was the idea behind it. So that's the timing issues, which is in the proposed Rule 29. The second part is in this proposed Rule 30, and I think that goes more to some of the issues we've heard arising out of the convention. And the first one is about this idea of the two non-challenged arbitrators deciding the challenge of their colleague. And we have seen a number of cases where arbitrators are not comfortable with this, and the rule says that they must decide unless they are equally divided. And of course, the argument came up, does that mean equally divided on whether or not to disqualify, or is it a larger concept? So we thought it would be useful to clarify that we see this at least as a larger concept, and it should be taken as a larger concept. So if for any reason the two arbitrators are unable to decide the challenge, they can consider themselves equally divided, and it will go to the chairman for a challenge. The other interesting circumstance we'd seen a couple of times in terms of the disqualification is that you would have a disqualification, which essentially there would be an automatic suspension. So it just serves as a complete, sort of a wall goes down and the case comes to a screeching halt. And the process would go on and it would be decided. And at the end of that, obviously, the suspension is lifted. We saw in a number of cases where there was a challenge and you would be mid-challenge and then another challenge would come in. And we even had a debate, how can that other challenge even come in the door, because everything is halted? And you would get an odd circumstance where you decide the first one, the case is on, but then it has to suspend again for the second challenge. And it seemed again like one of those things where it could be dealt with more efficiently. We had a number of parties come to a consensual arrangement, let's have them both dealt together. So that sub 2B basically said if you have that kind of a circumstance, they will be dealt with together and decided by the chairman. So those were the two kind of responses to some of those hardwired provisions in the convention. The other thing that I think is interesting here is we took away, first of all, the automatic suspension. And the question was, if you haven't got an automatic suspension, what is going to happen, and what if there are other things to be decided in the interim? And a lot of discussion about this, but we came to the conclusion that with a provision that was quite expedited and as well had to be brought within this 20-day time frame, there would probably not be a lot of decisions to be made, but it was important that the rest of the case could continue. So for example, you didn't want parties to be able to say, oh, this has been suspended for 5 months for a disqualification, so every other date in my timetable goes back 5 months. So the proposal that we have come up with here essentially is that the tribunal still operates, and if at the end of the day the challenged arbitrator actually is disqualified, either party has the right to ask for a reconsideration of whatever decisions they made. And we thought that was an appropriate balance, and we will see kind of what the reaction is to that. But those are the provisions on disqualification.
I wanted to move on to the proposed changes to the transparency provisions. Could you please tell us about that?
Yeah. Again, transparency is one of those ones where we did a lot of looking at the comments and trying to calibrate the proposals to what would be acceptable to a large number of states using the system and investors using the system. We had a number of comments, you will not be surprised to know, that said, just go straight to the level of transparency you have in the Mauritius Convention. But if you look at the Mauritius Convention, there's only been about 4 states that have acceded to that. So we said, even if you think that's the statement of principle, we're not going to get very far with it, so it's not a useful direction to propose in these rules. We also went through a number of the BITs and multilateral treaties to see the kind of transparency provisions that states have among themselves, and there is a huge variety. And interestingly, even the same state will sometimes have very different transparency requirements, and clearly it is a negotiated item when the treaty is being developed. So we looked at this and essentially said, what's the most important part here? And responding to a lot of the commentary that's out there, we thought what was really important was to try and support consistency and cohesiveness in decision making, and you can't have that if you don't have decisions. So decisions, orders, and awards to us seemed like a very special category of documents that really ought to get out and be in the public domain. So in this respect, we actually came up against another one of those convention hardwired provisions, and that essentially was the idea in the convention that says an award cannot be made public without consent of the parties. important to keep in mind, an award essentially at ICSID is that final document at the end of the day that has everything. And decision and order in ICSID parlance essentially are those kind of interim decisions on various motions, etc. So with awards, we put a provision essentially that said, that recognized it needs consent, but we said unless we hear from the parties within 60 days, we are going to deem consent. And so essentially, a party that does not want, or both parties, if they do not want the document published, they have an easy opportunity to simply say, we do not consent to publication. But one of the experiences we've had is parties, I think at the end of a case, basically, often just kind of move on to the next thing, and we didn't have consent or not. And ICSID would be writing saying, can we publish this, and not getting any clear direction on it. So we turned it around and said, we will publish unless the parties say no within 60 days. So that was the first part. Secondly, we said the parties, if they think there are things that need to be redacted, truly confidential information, they can advise us and we will publish with those redactions. And otherwise, we will do what has been done since 2006, and that is essentially to do the excerpt of the decision. We also put a discipline on ourselves in terms of putting a process for consulting the parties on excerpts and for getting them out, I think 60 days after we get the comments back from the parties. So we've also put a time frame and some discipline on the excerpting. So that's awards under the convention. Otherwise, the publication of decisions and orders, we essentially said these will be published within 60 days after they are issued. And again, we said if the parties want to notify that they have any concerns, they can propose redactions. If parties come to us with agreed redactions, we will just publish with that. If there are disagreed, in other words, redactions not agreed to, we are going to ask the tribunal to make that decision, and whatever the tribunal comes out with at the end of the day, that will be published. And that, I think, takes a page out of Mauritius, which essentially takes those redaction debates to the tribunal. So you have a process and a way to get those documents out. That treatment of orders and decisions is the way awards, orders, and decisions will be treated for the additional facility purposes, where you don't have that provision in the convention with mandatory consent. So it's that category of documents that basically will be going out, and I think that's going to have a very good effect. It will be well received. So that is publication of orders. Otherwise, parties are entitled to publish their own types of documents if they want to, and we will publish those documents where there isn't a debate about redaction. So if a party wants to put its counter memorial, we're happy to put that out, but we haven't regulated it in this set of rules. In terms of observation of hearings, it is similar to what it was before, which is essentially we will have public or open hearings unless a party says no, they do not consent to that. So it's much as it has been since 2006 in terms of actual observation of hearings. So those were the sort of, the documents and open access to documents and to hearings. That takes you into that interesting realm of non-disputing party and non-disputing party submission. So we've done a few things here that I think are interesting, and I'm going to be very interested to see the kind of response we have to this kind of provision. So essentially, we've put two provisions forward here. The first one is essentially submissions of a non-disputing party. And as before, you have essentially a two-stage process. First, where the non-disputing party asks for permission to file the submission, and if they get that permission, they file the actual submission. We had some interesting suggestions about putting this, for time's sake, into just one step. Basically, ask for permission and attach the submission you want to file. And it does make a lot of sense from a time perspective. But then you start thinking about that problem. I mean, you can never kind of unread. And the problem is, will parties feel there was a prejudice of the tribunal actually seeing the submission while they are at the same time deciding on whether the submission could be filed at all? So we kept with the two-step process, and we kept the criteria that have been used in the past, but added two. You'll see at the bottom, criteria D and E, is that the non-disputing party has to tell you about basically their organization, ownership, that kind of issue, basically describing themselves. And the next factor we added was whether there was any kind of financial or other assistance for the non-disputing party submission. I think those criteria probably were disclosed or addressed in most requests to file a non-disputing party submission anyhow, so I don't think it's that different, but we felt it was worth explicitly putting it in the provision. The next thing we did that I think is new, there is one other thing in that provision I should say. Again, we kept this whole idea that a non-disputing party submission should not overburden the process, and we have the same kind of language as we did before, but we put forward a proposal as well that the tribunal has discretion as a condition of allowing the NDP submission to ask the NDP to contribute to the costs that would be increased as a result of their submission. And this comes essentially in response to a number of awards recently, and I think they're cited in this paper, but a number of awards that have said an NDP submission and considering whether to accept the submission and then addressing the merits of it can be a very big thing for all parties and can increase the costs both of the tribunal and of the parties. And so it's something that does need to be factored in. On the other hand, you say to yourself, if this is essentially public interest participation, should you really be conditioning costs and payment of costs? And that is a difficult balance. And so we thought what would be worth discussing, and the proposal that is here, is that the tribunal has discretion to condition payment of some costs by the proposed non-disputing party. So that is certainly a very new submission, and I'm certain we'll get a fair amount of feedback on whether that is a good idea or not, and that's obviously the point of a consultation period. So that's the non-disputing party submission part. We also added a non-disputing treaty party submission. That had not been in the ICSID rules before, and treaty parties had basically been participating under the rule that dealt with non-disputing parties specifically. We thought it was a good idea to put this in, and essentially the provision says a non-disputing treaty party, in other words, the other party to the bit, that kind of a party, would have the right to make a submission on the interpretation or application of the treaty. And I think that language is quite familiar from those treaties that have that kind of a provision. In one sense, this responds to what we've been seeing increasingly, which is tribunals actually saying, well, what does the other treaty party think of this? Can we send a letter and ask them, do you have travaux or do you have a view? So we've increasingly been seeing tribunals interested in the other other treaty party's view of the treaty. But we also thought it was very important to say that right that they shall be allowed to address is with respect to interpretation or application of the treaty, and that if a non-disputing treaty party wanted to address other parts of the case, that should be through the Rule 48 mechanism, the mechanism that applies to any non-disputing party, where you have to request permission and meet the criteria. So I think in many ways, certainly it gives a right to the other treaty party, but it is a circumscribed right to treaty interpretation.
And I know that some of the treaties, as you just alluded to, contain this right to submit on the interpretation of the treaty. Have you seen this provision used a lot in exit proceedings already?
Well, we've seen it with treaties, and I think the one most would think about is this 1128 of NAFTA.
Yeah.
And I think there's at least 30, 35, maybe more submissions by the other NAFTA parties. And I think that's probably the example you most often see. But what's been striking to us is not infrequently tribunals now are saying, let's hear from the other treaty party, even when there isn't a specific provision.
What is the new proposal with respect to the procedure for bifurcation?
Yeah. Again, bifurcation is one of those things I think we all took for granted. Of course, you can ask for bifurcation, but you could not zero in on a bifurcation rule. So we thought it was a good idea to actually have a specific rule for bifurcation, and in particular, where the request is to bifurcate for a preliminary objection, that had to be made as soon as possible and at the latest 30 days after filing the memorial. And again, that responds to the whole issue of timeliness. And if you are going to bifurcate, you have to do that earlier in the process and not later. And we've seen a number of cases where requests for bifurcation came late, and it really does put a real crimp in the schedule and takes a lot more time. So we thought it would be important to set that kind of date. And then, of course, very specifically state what is it that's being bifurcated. So there is a rule, and I think a simple rule, but a logical one on bifurcation.
Could you tell us about those new mechanisms to increase efficiency and save costs, including this whole new chapter on expedited arbitration?
Yeah, exactly. This time and cost theme goes throughout the whole process, and a lot of comments received on time and cost. We addressed it in a number of ways. First of all, we have a general obligation to act in a time and cost effective or expeditious manner. And we have specifically said not just tribunals. I think we often say tribunals have to act faster and tribunals have to issue awards more quickly, but also that parties have to contribute to the time and cost saving approach to the process. So there is this general duty to act in that kind of a fashion. Secondly, there are a number of provisions where we have put specific time frames or specific conduct that we think will lead to a more expeditious process. So there are a number of rules throughout this process where there are specific, do this in X number of days, reply in X number of days. I think we just looked, the disqualification might be an example of that. So you have a number of those specific provisions. On awards, for example, we have said the manifest lack of legal merit must be issued in 60 days, which was the rule before, and we've kept that. That a preliminary objection award has to be issued in 180 days, and all other awards within 240 days. So we've put some numbers and specific guidance on when things have to happen. The third approach to this, I think, is probably a stricter approach to extensions of time. And on extensions of time, we've essentially said the parties can agree before the time expires that there will be an extension. But if you miss the date and you haven't consensually agreed, then whatever you file after that will be disregarded. So a consensual agreement between the parties to extend must happen before the expiry of a time period. The other part of this was what happens if your tribunal is not able to meet a time period, isn't able to render the award within the 240 days or whatever particular issue. And there we came up against an interesting problem, because if you put a hardline rule, if they don't decide in 240 days, that's it, you have really not done anybody any favors, because you then go back and start again or lose jurisdiction. So the approach to that essentially is that if the tribunal knows it will not be able to meet the time frame, they are required to advise the parties in advance to explain the reason for the delay and when they will be able to issue the award. So I know in some respects there will be those who think there needs to be a hardline rule, but that really doesn't do anybody any favors, as I say. So we thought this was a reasonable approach to really put some of those time frames, but also to make sure you don't turn the process upside down in the event. The last part of expedition was a whole process for expedited arbitration. And that was also an interesting one. We started out at the beginning thinking about basically small claims. And then you say to yourself, well, what's a small claim in investor-state arbitration? 5 million, 10 million, who knows? And is that really a very useful distinguishing factor? The other thing is, time and again, we've seen cases that might be on the lower end of the damages requested, but they might be very complicated from a legal, procedural, or other perspective. So this notion of a small claim wasn't especially useful. So we started to think about what's a better way to go about an expedited or fast track kind of process, and came up with a chapter essentially which we're calling creatively expedited arbitration. But what it essentially requires is for the parties to opt into this stream of expedited arbitration, and they must agree within 20 days after registration that we are going to go into this expedited stream. And essentially, the expedited stream has everything happening in quite quick time frames, and without sort of, bifurcating for a preliminary motion, or without a manifest lack of legal merit submission, or those kind of issues. So it is quite focused, and it takes, I think, about 150 days off the process at the end of the day. You still have a process that's going to take about 2 years, I think, maybe at a...
472.
Around 470 days, yeah. And, in fairness, we looked at that and we said, 470, no one's going to believe that's expedited. But then we went back and we said, what's a reasonable time to pick your tribunal, to file your memorial? And we wanted something that feasibly parties might well opt into. So it's not 60 days or 6 months, but we think it's something that could be a useful tool. And that's how we designed the expedited arbitration rules.
Thank you. I want to move on to the conciliation rules. What are some of the highlights of the new provisions in the conciliation rules?
Yeah. I've always said that I think that there was a lot of foresight in 1966 to even put conciliation rules. We often sort of talk about arbitration, ADR, conciliation, and I've had a number of parties sort of say those conciliation rules, they look very legalistic and filing documents and those kind of things. But if you put yourself in 1966, I actually think that was very creative and, really quite impressive to have those rules. Move ourselves forward to today, we know a lot more about conciliation, and the idea was to make this a more modern ADR type tool that was more flexible and allowed the conciliator to actually go in and try and be more of a sort of problem solver type of role. So we've tried to make them more flexible. Unlike arbitration, the presumption with conciliation remains that these documents are, and that the process is confidential. And I think for most people that stands to reason in terms of the nature of conciliation. We've also underlined the rule that was there before, but often overlooked, which is that you cannot make any collateral use of documents in conciliation. And I think there were a number of parties who wanted to try conciliation, but were worried that the very fact of doing so, or a position taken during conciliation, would be used against them if they ultimately ended up in arbitration. So we strengthened this sort of no collateral use of information that's gained in the conciliation process. We kept the possibility of a 3-person conciliation panel, but there is clearly a preference for sole conciliator, and that's based on feedback we've received from parties that seems to work very well. We very clearly delineated their powers and included things like they may, recommend specific terms of settlement, recommend partial settlement if they would like. They can recommend that the parties refrain from aggravating conduct for the process. They can request explanations from parties at any time. So it's much more, I think, like what you think of as the sort of modern type of conciliation rule. It starts with written statements by the parties, but from there on, the type of written documentation will be up to the conciliator based on what they think is useful. And at the end of the day, we've said if the parties do settle, they can file the agreement noting their settlement, and that was specifically intended to take advantage of this new Singapore treaty that's recently being entered into. So it links up an ICSID
Yes.
conciliated settlement with that conciliation treaty generally.
Moving now to the additional facility rules, what are the most significant proposed changes for ICSID and its users?
There are some very new things in the additional facility rules, and I think this is actually, I know it's at the end of the document, but one of the more interesting parts of all of this. The first thing is that we have proposed to expand the scope of additional facility. Currently, essentially, and this is a simplistic way to describe it, but currently an additional facility case has to have either a claimant whose home country is an ICSID member state or a respondent who is an ICSID member state. So essentially one side of the equation must be an ICSID member. We looked at that again and said there really isn't a need for that, and there's no reason these rules should not be available, for example, between a claimant and respondent whose state is not an ICSID member. So that's the first big change to these rules. The second one is allowing an REIO, Regional Economic Integration Organization, and I think the one everyone automatically thinks of is the European Commission, or European Community, but that an REIO could essentially sue or be sued. And we looked at that, and certainly we all think about the EC now, but that increasingly is a way that parties are approaching treaties as regional economic integration organizations. So we thought, if you have a treaty signed by an REIO, you need the other part of it, that they can actually participate in the dispute settlement, so that this made sense. So we've specifically allowed the REIO to be a party to the arbitration, conciliation, whatever process under the additional facility. Third thing was a complete revamping of the fact-finding rules, and as I say, they have never been used. But hope springs eternal at ICSID, and we actually changed them very significantly, and I think this could be a very useful tool. Obviously, it takes the right case where some pivotal fact is going to make a big difference in what happens in dispute settlement. But where you have that, I think the ability to go and have a precise fact-finding is actually a very good tool. So that is in the additional facility rules. And the last is this entirely new set of mediation rules.
You just mentioned a new set of mediation rules. There is a perception that state parties are not open to settling their disputes through mediation. How do the proposed changes would encourage and facilitate mediation between international investors and state parties?
Yeah, it's interesting because I know there is that perception, but I think it's fair to say probably more often it is a state saying to us, we would like the option of mediation. It still hasn't happened that frequently, but we've heard a number of states saying we would like that option. So we think that just the mere fact of having that set of rules will enable parties to take advantage of it, and once you start creating this track record, hopefully of successful mediated disputes, it will build on itself.
You said in an earlier talk that what is possible through the rules amendments is limited by the ICSID Convention, of course, which the Center may seek to revise for the first time after the rules amendments. Could you give us some of the examples of the reform, of the changes that the users have voiced as desirable that would require amending the ICSID Convention? Yeah,
there are a number of areas where either states or investors have said a change should happen, but when you look at it, it's in the convention, and this is a rules amendment process. But what you see here is we have very explicitly said throughout the document, it's proposed to do A, B, C. We are not proposing to do something else because that would require convention amendment, but members may wish to come back to this. So essentially, throughout the document, we have flagged areas that might be worth looking at a later date for a convention
that
amendment.
working paper, right?
That's exactly it. And I actually have a list. There's about 10 things, and some of them are very, very simple. For example, states are allowed to put 4 arbitrators and 4 conciliators on their lists from which nominees may be drawn. That was done when you had 1 or 2 cases. We now have, at any one time, about 250 cases ongoing. I think there is a very logical reason to have many more nominees in that pool. It would require a convention amendment, but I suspect that would not be a difficult convention amendment. We talked about the disqualification rule. That's one that perhaps would require more discussion, but it's one that may be timely. So we thought it was worthwhile as part of this process to at least flag, here's something that you might want to come back to.
So getting now to the next steps in the process, what are the next steps for the state parties and what is their role? And somewhat relatedly, is there any concern that some state parties may not be able to really review everything and participate or not have the capacity to do so?
I think the concern for both state parties and investors, know it's a big document, but we are making every effort to make sure that we are explaining the main proposals. So, for example, today was sort of the first trial run of this, but over the next 3 months until the end of December, we're going to put a series of videos on the website, each on a specific topic proposed for change. We're going to do some webinars about the changes proposed. We have a number of in-person presentations in every one of our regions, and we're available for briefings with states or with any others who want to talk about or ask questions. So we're making every effort to be available to answer any kind of questions that come up. We are having a 2-day consultation at the end of September with the member states, and actually the member states and signatory states, and we are looking at that essentially as an opportunity to go through and first of all just explain what is in this document that you ought to know about, and a first opportunity to hear from states, what's your response to this, what's your reaction, do you think this is something you could support? But we are saying very expressly, we know this is probably the first run at the document for a number of states, so we're not expecting any state to come with a hard and fast position and please change this comma and this word or anything like that. It's really to make sure states are familiar with this. And we have asked and invited both states and the public to give us written comments, which we are posting on our website. And so all the comments from the public will automatically be posted, and they are requested on or before December 28th. And we have said to states we will also, with their consent, post their responses to this package of amendments, again by December 28th. So key dates for us are this consultation at the end of September, December 28th, where we will have presumably a stack of comments, hopefully a small stack of comments, because that's our reading. And we will go through at that point and say, what is it that there is clear consensus on? Is there something we need to completely rethink? Is there something that we just need to put on the shelf because there won't be consensus? And at that point, make the strategic decision about whether we can put a package together for a vote at the October 2019 annual meeting of our members, or whether we need to go back and change any particular parts. The scenario that I hope and that I think is possible is a vote by the states in October 2019. If there is a lot of comment and things we have to go back to, that vote would be the next annual meeting, October 2020. But that's the rough time frame. The other thing that we've done in terms of making this accessible, obviously all of these are English, French, and Spanish, but we're also putting some other language versions of the synopsis. So we now have the Mandarin version. We have an Arabic version, and I think we are working on a Russian version right now. So we are really trying very hard to make sure nobody can say they didn't have a chance to understand what was being proposed.
Is the role of the general public or other stakeholders a little bit different in the process?
I mean, it's essentially the same in that we've said, here are all these proposals, and any reaction and commentary is most welcome. I think one of the things, though, that we did find in the first round of requests for comments was that we had a number of lawyers and law firms who gave comments were actually very, very useful, because many of them tended to be the more sort of technical ones about how this rule doesn't work because of this thing. And while it's hard to generalize, I think the state comments were more, you might say, sort of policy focused or big picture focused, whereas a lot of the comments from legal professionals were, here's an experience we had on a case and this is something that needs to be adjusted. So it was very useful for us to have both and be able to address both on that sort of technical level and also on the bigger policy or principle level.
I would like to allow our audience to ask some of the questions. I don't know if you had an opportunity to write them down on note cards. If not, now is the time. And I have a couple of more questions while the audience is thinking about their questions.
If you'd like an index card or a pen, I have them here. If you have already written your question down, just pass them to the middle and I'll walk through and collect them.
While we're getting the questions, I just had a couple of other more overarching questions. What was the rationale behind streamlining all the rules? I mean, that required you renumbering them, right?
Yeah.
It's going to look very different if they are adopted from what we're used to working with.
Yeah, and I know there will be a certain amount of wrath when people now can't say it's a 41.5. I mean, we've all kind of gotten used to this shorthand, so we'll have to get the new numbering. But once we started to make adjustments, you then started to realize you couldn't leave the other provision untouched, and it had to fit together as a whole. So as the process went along, we realized we basically need to start from one and work ourselves through. And it's a very interesting process, because something that you change in Rule 2, you realize in Rule 42, oh yeah, but we said this, does that work with this? So really, you needed to look at it as a comprehensive whole to make sure it all fit together.
Again, referring to something you said earlier, you said that that some changes voiced by the users are actually more adaptable through soft law tools.
Yeah.
Could you give us some of the examples of such changes?
Absolutely, and I think one of the dangers we were aware of is this potential to over-regulate or overuse the legal tool and try and address every single possible situation and permutation. And certainly when we went through doing the drafting, we would sit there and do, the what if and all of this kind of stuff, and you try and test it against that. I can guarantee that something that none of us think of in the next year or whatever of consultations will come up and we'll go, oh, why didn't we think of that? What if? But the idea was you need to make these usable, readable, comprehensible. So there are a number of things where you might want to regulate is probably not the right word, but work with, but they're better done through what you might call a soft law technique. So guidance notes, for example, case management techniques, what's the role of a secretary? How do you manage documents for publication? Those kinds of issues are things that we can usefully give information on, but we didn't think it was the kind of thing that should clutter up a set of procedural rules. So we have sort of put notations throughout, we will do that. And in fact, I think we did a number as we were going through this process of rulemaking. There were a number of things we said, oh, we ought to have guidance on the web about that, and we actually did it. So we've kept a running list. Procedural techniques for multi-party cases was one of the big ones that we thought this is worth thinking about, but as a soft law technique and not hardwiring it into the rules. So this is an ongoing process.
I think we have some interesting questions from the audience.
Alrighty, let's start here
It's your
at the
pick.
top. How has the adoption of the ACMEA decision by the European Court of Justice impacted your rules review? ACMEA is ongoing and fascinating. I don't think we have made any kind of a rule amendment proposal that you would say specifically responds to the ACMEA situation. So that essentially is a legal question that is coming up under the current rules, could easily be raised as a preliminary objection under the new rules, and so I wouldn't say there's a specific rule proposal that addresses the ACMEA situation.
Another question, any amendments to the post-award process?
Yeah.
And some states seemingly use annulment proceedings to delay enforcement. Comment.
Interesting. I've heard that view before. Some agree with it, some don't. On the post-award process, we have certainly put some very definite time frames in the process, and I think it's 180 days for an annulment to be decided. We have also suggested that the norm should be one set of pleadings for annulment as opposed to reply rejoinder, two set of pleadings. So there are a number of steps to try and make that a more expeditious process. I think that would be the main thrust of the post-award changes.
This is an interesting question. What are the major differences between the additional facilities mediation rules and the exit conciliation rules, if any? If
you look at it, essentially, under the convention and the additional facility, you each have, first of all, arbitration rules. They're very similar, maybe about 8 to 10 differences. Same thing with conciliation, very similar. And it is only the additional facility that has fact-finding or mediation. If you want to compare conciliation and mediation, I think the best way to say is the mediation is just even a step more flexible on the sort of spectrum of what kind of a role can the adjudicator have, and to what extent can they basically tailor the process for the parties at the end of the day. So the question is, one of the issues we've discussed was the ASIL-ICA task force, how to avoid damage awards where the tribunal departs from methods as well as amounts calculated by the experts and arrives at its own calculation using methods that would be unacceptable to any expert. The updated rules don't address this. The one thing, I guess, that is relevant in the updated rules that I would point to is that we have put in the evidence section a specific rule allowing a tribunal to have a tribunal-appointed expert. This is one of those practices where it happened and we all seem to take it for granted, but there actually wasn't an anchor in the rules. So that is now specifically proposed. In terms of whether the expert calculation is done appropriately or not, that's still a question for greater minds than ours. So that's a question for the experts in the tribunals.
I had another question that I thought it would be interesting to talk about. There's a proposed rule on the tribunals and parties' duties, which essentially confirms the application of certain fundamental duties that already exist and adds the duty to act expeditiously as well as duty to cooperate and implementing the decisions. Why has it become important to have this as a rule? How do you see it being used by the parties?
This rule, and it's at the beginning, it's I think Rule 11, essentially you might say it is, sort of like hortatory treaty language. It is, you should cooperate, you should act expeditiously. It doesn't impose, I think, any kind of, it's not like a do this in 200 days kind of thing, but it certainly was important as a statement of principle and at the beginning of the rules to complement all of the other efforts that are made to make this a time-efficient and cost-effective system. And I also suspect these are the kinds of general obligations that will be cited by parties as para 2 of their brief, and then they will go into specific rules on you must do this or you must do that. But we thought it was really important to make that statement of principle at the beginning, that this is really something that has to be addressed, and addressed not just by tribunals, but also by the participants.
Well, Secretary-General, thank you so much for being our guest tonight and for unfolding a little bit the working paper. Actually, I feel like we learned a lot tonight, and thank you everyone for joining us. Please stay on for the reception. Thank you.
Thank you.